I'm going to call the next three cases and explain what I think is going to be the order of the arguments, and if I got anything wrong, someone will correct me. People versus Peeler, People versus Lyon, and People versus Baird. These are 15-minute mini oral arguments on the application, although there also is some argument time for amici. My understanding is that Mr. Bursch will start us off and will reserve time for rebuttal if he can manage it. He's good at that. Mr. Schindler will go next with 10 minutes of argument for amici. Then we will hear from Mr. Kessel, and then Mr. Bursch will come back if he has reserved any time. So,
Madam Chief Justice, we're happy to go first, but the calendar we have in the clerk's office is that it was People versus Keeler first, then People versus Lyon, then People versus Baird.
oh, and I am sorry, that is correct, and that's where I went wrong. So I am just looking at the second case, and I almost skipped over People versus Peeler. So let's start with People versus Peeler. Mr. Gurewitz, we'll hear from you first. I just wasn't looking at the top of my page. I apologize. Mr. Gurewitz.
May it please the Court, Harold Gurewitz appearing on behalf of Appellant Nancy Peeler. I would like to reserve 4 minutes, please, for rebuttal. Ms. Peeler is asking this Court to hold that she and 6 other individuals who have been charged in Flint, Michigan, as well as dozens of others who have been charged since the erroneous opinion of Judge Kelly of the Circuit Court on this issue, have a right to a preliminary examination after the investigation which brought their charges pursuant to MCL 767.3 and 767.4 particularly. We have asked this Court to find that 767.4 requires that the Court proceeds in a manner pursuant to the statute, because it specifies that the Court proceed in a manner by which it conducts an examination. The language is that it shall proceed in a manner as upon formal complaint. Cases that have been cited in the response briefs, particularly at their supplemental brief at page 19, confirm that the procedure upon formal complaint or a written complaint, is that which continues with a preliminary examination. The judicial inquiry statutes with which we're concerned have required the same procedure since enacted in 1917. It was precisely the same language that was used at that time and adopted from an earlier 1885 police judicial investigation statute. The 1917 Act has been amended substantively 4 times since that time, in 1921, 1947, 1949, and again in 1951. But the same language to proceed in a manner as upon formal complaint continues. The statute is unique, and Justice Black, I believe, and In re Oliver for the U.S. Supreme Court in 1948 described it as unique. It is one that provides for judicial investigations. It's unique because the position of the judge in that procedure is one in which the judge wears multiple hats, acting as an inquisitor, acting to authorize subpoenas, and acting to grant immunity. It is not the equivalent, as Judge Kelly erroneously held in the Circuit Court, of a citizen's grand jury proceeding. 105 years after the date of its enactment, the same language, the same phrase, to proceed as upon, in a like manner as upon formal complaint, continues to be part of the statute. The question we're presenting is not one in which we're asking this Court to virtually act upon a blank slate, because there have been decisions by this Court over the intervening time period which have affirmed this practice. In 1942, 25 years after the statute was enacted, in People versus McCrae, this court held that 767.4 authorized and empowered the judge to conduct a preliminary examination. It referred as well to a statute which is now which was the equivalent of what is now MCL 750.10.
Counsel, good morning. I just have a question. I always like to kind of get right to kind of how this, what the specific nature of the impact. Could you tell us, I know it might sound simple, but I think it's important to understand, what is the specific harm to your client?
The harm to my client is denial of a right to a preliminary examination, which this court has consistently held is a substantial right that includes the right to confront witnesses, to review discovery, and to understand the theory of the government's case so that it can be challenged in a pretrial proceeding. It's a right that was specifically enacted by the legislature in 1917, and it's the denial of that right about which we're complaining.
Thank you, counsel.
Thank you.
Counsel, let me interrupt you for a second. The evidence that you and Mr. Barrett's counsel and the criminal defense attorneys of Michigan have submitted makes it pretty compelling that preliminary examinations were the norm or common until our decision in Glass. I assume you're familiar with Mr. Lyon's briefing that it isn't perfectly clear that the statutes even authorize a judge to issue charges, to act in an executive officer capacity. That's not an argument you have made. Assume we agree with you. Do you have a view on Mr. Lyon's argument about the power of a judge to act as an executive?
Yes, I do. Thank you, Your Honor. That argument is completely consistent with the one we've made, and it's consistent with the history of the way 767.4 has been implemented. In some cases, as we have pointed out, I believe, the result of a proceeding has been the issuance of a warrant by the examining judge on which a preliminary examination has taken place. We have also agreed with Mr. Lyon's brief particularly, and I think that we included an argument based upon due process as part of our supplemental brief, which explains that the actual conflict in roles in which the judge sits both as the investigator and then is required to function in a position in the process that was used here to determine the nature of the charge is one that raises the appearance of actual bias. And I have relied upon the relatively recent case of Pennsylvania versus Williams versus Pennsylvania, in which which Justice Kennedy concluded that that is a disqualifying due process violation. That's inherent in this procedure. It is our position that the judge, that there is no actual direction of authority in the statute. And it's interesting, as I think I noted in our briefing, that in fact the order that was entered by Judge Beagle appointing Judge Newblatt to act as an investigator makes no specific reference to any authorization to issue charges. The same the same observation was made then in 1967 and in Ray Casides, another case that proceeded from a contempt finding by a judicial investigation, in which the court identified the evils, much the same as those were outlined by the Special Committee of the State Bar in 1947, one of which included the role of the judge in the McCrae situation, acting as both the investigator and the determiner of probable cause. In 1972, this court decided People versus Duncan concerning whether or not a defendant charged by a citizen's grand jury is entitled to a preliminary examination. And as part of the analysis to reach that conclusion, relied upon this statute that we're talking about and says that it particularly it's an example of a statute which requires a preliminary examination. Nothing has changed since 1972 to the present time. There's been no amendment to 767.4 to create a right to a preliminary exam, to diminish the right to a preliminary examination. I'd like to address also the 1947 amendment to 767.4, which incorporated the language that says that the judge conducting the inquiry under the statute shall be disqualified from acting as the examining magistrate. The language was placed there particularly by referring to the examining magistrate to ensure that what happened in McRae would not happen going forward. The State Bar Journal at 26 MSBJ 1947, pages 57 to 59, outlines the rationale that was apparent to those members of the committee, which was later specifically cited in the Duncan case. And it says that there were three methods of bringing a person into court at that time on a criminal charge: indictment, complaint and warrant, and the third alternative means a complaint and warrant issued by a one-man grand juror. It concludes by saying, and I quote, "Hence, the important thing to bear in mind is that the accused is entitled to a complete examination before some magistrate other than the grand juror, before being bound over for trial, and thereafter the accused is also entitled to a trial before a regular jury presided over by a different judge." That requirement remains a part of the statute for the same purpose, and it's for all of those reasons, then, Your Honor, that we ask this court to conclude that the statute means what it has always said. It means what it was intended to provide for in 1885, when the same language was included as part of a police justice investigation procedure, and when it was then incorporated into the predecessor of 767.4 in 1917. I think I have reached the limit of my time, except for the time I have reserved for rebuttal.
You may reserve your time, absolutely.
Thank you.
Mr. Kessel, I apologize again for calling the wrong case first. You're going to be up here a lot, so.
I was going to say, Judge, I'll be here all day. So. Well, Madam Chief Justice, Your Honors, good morning. Again, my name is Chris Kessel on behalf of the people. Your Honors, with me, I believe you all are familiar with Solicitor General Fadwa Hammoud, on behalf of Kim Worthy and the Wayne County Prosecutor's Office, Molly Kettler, and Assistant Attorneys General Gallant Fish, Dan Ping, and Bryant Oskowitz. Your Honors, the first words of MCL 767.4 state that if upon such inquiry, the judge shall be satisfied that any offense has been committed and that there is probable cause to suspect any person to be guilty thereof. This court has repeated that the purpose of a preliminary exam is to establish probable cause that a crime was committed and that the defendant committed it. It is no coincidence that the language of these two procedures is almost identical, because both serve the exact same purpose: to establish probable cause that a crime was committed and that a defendant committed that crime.
I mean, but one happens in public and one happens in secret, right? I mean, even if the standard is the same, in a preliminary exam, the defendant gets to see and hear the evidence and challenge it, right? Isn't that an important difference between them?
Your Honor, just like with a citizen grand jury, with a one-person grand jury, yes, the probable cause finding is made not in the public domain.
But a citizen grand jury stands between the accused and the government, right? We get our fellow citizens get to stand between us and the government. Here you have the government standing between the accused and the government. I mean, there are important differences. I mean, all right, go ahead, sorry.
No, it's your courtroom, Your Honor. No, Your Honor, I appreciate that point, but what happens in a one-person grand juror investigation is exactly the same functionally as a citizen grand jury investigation. There is a grand jury, whether it's made of one person or whether it's made of 17 or 23 individuals. And that grand jury, no matter what the constitution thereof, makes a decision about probable cause. It's the probable cause determination that every defendant is entitled to. Every defendant is entitled to probable cause finding before you are in a felony case bound over for trial. And that's the issue, Your Honor. I think you're right, is that all of these are probable cause findings. They may come from different sources, but that's what defendants are entitled to. The rights that you discussed when you have a chance to challenge preliminary evidence at a preliminary exam, no defendant has that right in a citizen grand jury, and I don't believe Mr. Gurewitz or Mr. Bursch or anybody else is challenging, for lack of a better phrase, the legitimacy of a citizen grand jury. There is still that procedure that takes place, yes, behind closed doors. But all of those rights that you discussed, cross-examining, challenging a case, those are for due process purposes, Your Honor. Those are trial rights. And all of those rights are still guaranteed to any defendant, no matter how they are indicted, whether a citizen grand jury or a one-person grand jury. And what's also important to remember, Your Honor, on that point is, as this court said, pretty sure it was Duncan, is that the right to a preliminary exam or a grand jury indictment, both are statutory, neither is constitutional. What's happened is our legislature has decided that there are a number of ways that a prosecutor may decide to investigate someone, or a grand jury may be formed based on a complaint. Sorry.
No, I can understand the reason why a prosecutor might prefer to use a one-person grand jury as an investigatory body. That makes a lot of sense. There could be cases where a local prosecutor thinks it might make sense to be arm's length from the investigatory part of a case. But the charging part is usually the prosecutor's decision, right? I mean, those feel different to me. Do you have a response to the evidence that we've seen that it seems that defendants commonly receive preliminary examinations prior to our decision in Glass?
Absolutely, Your Honor. So the people's position is that there is no question that these preliminary exams, at least in these cases, did seem to take place. The question becomes, is this examining magistrate language? Is it codifying a right, or is it recognizing what was common practice? And what this court in Duncan, even though this court in Duncan was overruled in Glass because they went too far, they created a substantive procedure from a court rule. But what even the court noted in Duncan was that there were sometimes preliminary exams taking place with respect to citizen grand jury indictments. They say sometimes they were before the indictment, sometimes they were after the indictment. And what Duncan says is that we recognize that this may have been common practice, but even Duncan says there's no right to these hearings. And it was this sort of rationale that Glass really doesn't overrule. What Glass overruled was this court in Duncan sort of overstepping its bounds. And if I can, what this court said in Glass precisely was that the establishment of the right to a preliminary examination is more than a matter of procedure and beyond the powers vested in this court by our Constitution.
But counsel, I have a question, and I appreciate your answer. And just to kind of follow up on what the Chief's question was, you brought me to this question is, I mean, ultimately, like I say, I like to look at everything kind of from a practical perspective in terms of just looking at it from a simplistic but very practical basis. On a case of this magnitude, on a case of this significance, doesn't it make more sense to make sure that whether it's true or not, that there's no perception that the government is cutting quarters?
Your Honor, I certainly appreciate that question. What I would respond to that is what this court said in Colacasitas was that one-person grand juries are particularly important just for cases such like this, where the allegations of government corruption at the highest level do result in the victimization of an entire city. Now, I appreciate that defendants want to have a preliminary exam, but defendants are not entitled to choose their right of prosecution. And that's really what this boils down to, Your Honor and Your Honor.
But doesn't it just make more sense so that basically because of the nature and gravity of this, that every aspect of the cornerstones of basically the criminal justice system is put into place so that as history looks back, they can say, and you can say that every aspect of this was followed and done to the T because the system and the specific nature of what was at stake was adhered to. Just because of its importance, because of its significance, because of its impact, isn't it just always best to make sure that you just do everything perfectly without even a question?
Well, Your Honor, I would respectfully say that the people's position is that this was handled correctly and that the legislature, in their wisdom, we'll call it, has decided to create multiple avenues of investigation and prosecution. And it is the responsibility of the people to use whatever tools the legislature has given them. And in this case, after consultation with Kim Worthy and the Wayne County Prosecutor's Office, it was the decision of the Office of the Attorney General to pursue this specific method of prosecution. And I'll tell you, Your Honor, there are a lot of reasons why this kind of prosecution is especially necessary in cases like this, where I said we have high-ranking members of government with the potential to involve themselves in prosecutions. We have witnesses that are concerned about their jobs or about their safety. We have people who may or may not have wanted to come forward.
But Counselor, isn't that all protected by having an inquiry process first and then a prelim later? You still can, I mean, the way we saw this in practice through last century, mid-century, they were corruption cases. And it appears that the courts had, the one-person grand jury, and then there was a prelim that seemed built into the process. It seemed understood. Why did they understand that? Why was it the common practice?
Your Honor, we've bandied that question around quite a bit, and the truth is, there is no knowing the answer to that question. There's no denying that it's something that happened. But when we're asking ourselves a question about statutory interpretation, the understanding is the first place we look is to the statute that we're dealing with. And there is no question that what the legislature wanted was the one-person grand jury to, not be within 100 miles of the case after an indictment was found. But there is simply no language in this statute that says that a defendant or a suspect or an indictee is entitled to a preliminary exam. I understand that there are policy considerations as to why another method of prosecution would maybe be preferable to some. But again, Your Honor, I would refer this court back to this court's words in Glass, which is policy considerations are not something this court should be engaging in respectfully when we're dealing with questions of statutory interpretation.
What should we do with? I'm sorry, go ahead.
I was just, what are we supposed to do with the fact? And I appreciate your point that these are, that this statute in particular, how it's been used historically, perhaps its best use is for high-level corruption cases or these sort of special cases. But my understanding is that there isn't some limiting principle, and a number of cases are being handled in this particular county by this method, right? Not high corruption cases, just a regular. So when we're, as you know, when we decide these cases, it's not just this case in front of us. What is our decision doing to the other cases that are coming down the pike, or that may be, not of this level of case, but a single individual defendant that doesn't have these same concerns?
Well, Your Honor, if I understand part of the multi-part question is, there is no limit to a prosecution's use of any particular form of charging. Yes, this court in Colacasitas recognized, and I think this court on some level recognizes, that yes, in cases such as this, it is very useful to be able to use a one-person grand jury. But there is no limit on how any particular prosecutor uses any particular method of prosecution. The prosecution is only limited by what tools it's given by the legislature. The legislature has seen fit to create, and this court in Picatino, when talking about the various kinds of grand juries, this court said there's a one-person grand jury, there's a three-judge grand jury, and there is the one-person and the citizen grand jury. And all three of those are legitimate alternative methods of prosecution that stand on equal footing. So the response, I guess the short response to your question is, there is no limiting principle. If the legislature wants to create a limiting principle, or if they want to try and do away with the one-person grand jury, then I would say respectfully, Your Honor, that's a decision for the legislature to make. But what they've done is they've created and enacted this procedure and seen fit to give it to the prosecutor to use correctly in conjunction with the statute. And I know it's tough because I know this argument kind of dribbles into the separation of powers argument.
Right, it's giving it to the
Yeah.
prosecutor to use to allow the judge to exercise the normal prosecutor function, right? Decide what charges to charge. I mean, it just strikes me as, I mean, I understand that we can look to the knights in England and figure out what they got to do, I guess, as judges, but inherently, that is not the role of a judge, is to decide, make charging decisions. And if there's no sort of limit, be it the big, public corruption case, to, the most mundane run-of-the-mill criminal case, isn't that a problem?
Respectfully, Your Honor, it's not.
Okay.
And like I said, I don't want to get too much into the due process stuff because I know we'll be back in a few minutes. But I think the issue, no, it's all right. Like I said, I'm here all day. The issue is, Your Honors, that defendants all have certain rights. Rights to a preliminary exam is a statutory-only right. It's not a due process right. It's not a constitutional right. The preliminary exam is something that was created by the legislature. Just like the one-person grand jury was created by the legislature, just like the citizen grand jury was created by the legislature. All three of these mechanisms have specific rules. And the one-person grand jury, just like a citizen grand jury, Your Honors, does not carry with it the right to a preliminary exam. And what I would suggest, Your Honor, as I see I'm almost out of time, is that if the court were to use the rationale that, well, we want all defendants to have preliminary exams, what this court would then have to do is not only dismantle the one-person grand jury, but it would also have to dismantle the citizen grand jury. Because if the court's concern is, well, we want people to have these rights for essentially policy reasons, Your Honor, then it would have to do away with any prosecutorial method that did not guarantee those rights.
Counsel, before you get to the end of your time on this, I think, because the next case might move in a different direction, what about just interpreting and applying the language of the statute? Isn't that our job to do here? And you've said that the statute doesn't say that a defendant is entitled to a preliminary exam in these circumstances. Of course, if it did, we wouldn't all be assembled here today. We rarely get cases where the language is that clear. But here there is language that certainly leads us in that direction, and the language that your opposing counsel already referenced, that the case, the judge shall proceed with the case in like manner as upon formal complaint. And then, of course, the very next sentence of Section 4 says that the judge conducting the initial inquiry is disqualified from acting as the examining magistrate. Why would the legislature go to the trouble of making it clear that the judge is disqualified from doing something if it's not something that they intended be done?
Your Honor, I see my time is up. If the court,
Please,
this,
as long as Justice Viviano wants you to answer.
Well, you can use it as part of your next 10 minutes, but I didn't want to go on to the constitutional issues.
I feel like the answer might take 10 minutes.
And it
but-
seemed pertinent because you kept saying there's nothing in the statute that says, like a billboard, you get a preliminary exam. But of course, the case is really not about whether it says that directly. The case is whether we interpret the meaning of the words the legislature used. What's the fair meaning of those as they intended them back in 1917 when Governor Sleeper signed this bill?
So, Your Honor, as I said, there's sort of multifaceted answer to that question. The first is, for example, in 767.3, what the legislature wrote is that a witness appearing before the grand jury shall at all times be entitled to legal counsel. So there we have a right that has been created by the legislature in the one-person grand jury statute, 767.3.
That's the only time in these two sections that it refers to this process as a grand jury. Is that not correct?
Your Honor, in 767.4a, it discusses the secrecy provisions on documents I'm sorry, and it talks about the grand jury, documents presented before the grand jury. So grand jury is used repeatedly. I understand that it's only used 2 times. I know that's been made an issue by parties, but the language is there. And so first we have a recognition that the legislature knew how to create these rights. The legislature never says a defendant, after a probable cause finding has been made, shall have the right to a preliminary examination. This clear statutory language, as exists in the right to counsel, simply does not exist with respect to the examining magistrate. What is clear, what is statutorily clear, is that the legislature did not want the one-person grand jury having anything to do with any aspect of this case once an indictment has been returned. So what this language does is not only recognize that this process was taking place, understanding that's not the same as guaranteeing.
How does the case proceed normally upon formal complaint in your office? If the Attorney General authorizes a warrant and a case is initiated, what happens next?
Your Honor, I have to be honest, I haven't been an AG that long, but what I
Well,
can
probably they may swear to the warrant, an officer will come in, an arrest warrant will be issued, the person will be arrested, they're brought into court, and then they have a right to a preliminary examination if it's a felony charge. I think that's how things go.
Your Honor, here's what I can tell you is my experience.
But let's assume that I'm right. That's how normal cases go, and that's,
He did it for a long time.
yeah.
I know.
I did parts of it, different bits and pieces of it. So the question is, when it says in like manner as upon formal complaint, what did the legislature mean by that? If not, proceed in like manner as other cases on formal complaint, meaning that if it's a misdemeanor charge, you don't get an exam, but if it's a felony charge, you do. If it's a misdemeanor charge, presumably the case would proceed in district court, whereas if a felony case would have to be bound over to circuit court. What else does that language mean, if not that?
Sure, Your Honor. So the judge having jurisdiction, if a felony indictment is returned, then we know, Your Honor, I suspect you know as well, a felony indictment is returned at the circuit court level. It's not returned at the district court. So the judge having jurisdiction then becomes the circuit court judge, whoever that may be, in this case, Judge Kelly. So we know that's the judge having jurisdiction. Now, the language upon formal complaint, that was not meant, again, to create a right of any kind. What that's telling the court at the circuit court level, or if it's a misdemeanor at the district court level, is that you are to treat this matter as though you had gotten it via this other procedure. As you are to treat it exactly the same as though it had been, you received it in an informational manner. And the reason they use that language.
Well, it doesn't say information, right? It says complaint. There's a real specific difference here that may matter, right? Because in circuit court, we get informations. We don't pay too much attention to the complaints. I always used to read them in the file. They usually say the same things as the information says, unless there's some change after the preliminary examination. But circuit courts get cases that are charged in information. Is that not correct?
Absolutely, Your Honor, but.
Where does that happen in this process?
Well, the point that I was immediately about to make, Your Honor, was that the formal complaint language encompasses all cases. Yes, all complaints are based on information, all informations are based on complaints, but not all complaints turn into information. Some just remain at the misdemeanor level. So when the legislature writes as upon formal complaint, it is using this broad language to encompass all the possibilities. So if you're a misdemeanor, a district court judge, I shouldn't say misdemeanor judge.
But if you have to go back to that point in time, all the possibilities include having a preliminary examination, don't they?
They don't, Your Honor, because that right, first, is never found in this statute, but also
Well,
this.
that kind of begs the question of the entire conversation we're having, but continue.
Your Honor, that the rights of a preliminary exam, if they exist, must be clearly and statutorily expressed. What the legislature expresses here is that they don't want the grand juror to have anything to do with the case. That the judge who has jurisdiction when they receive the case, that they shall treat it as though they had received it in, for lack of a better phrase, a normal fashion, as though it was received in any other way.
But a circuit judge never gets a case just based on a formal complaint. You agree with that?
Absolutely, Your Honor. But I think you would also agree that they do receive indictments.
I have to agree with you, although not ever in my experience. That's pretty rare. Although my dad did conduct a citizen's grand jury in the 1970s, so I'm sure that it has happened. But most cases proceed on information, right? That's how we, until apparently recently, and now in Genesee County, the prosecutors using this process, I'm told. Is that to avoid having to do preliminary examinations? Is that the reason, rationale for that?
Your Honor, obviously, I can't speak for the office of the prosecutor of Genesee County, but what I will tell you is, I mean, I know I made light of it, but up until recently, I've been a defense attorney for over a dozen years, and I have considerable experience with the one-person grand jury as a defense attorney. And it is not commonly used statewide, there's no question about it, but it is used, and it is just a method of prosecution, and you deal with the case as it has landed in front of you. You still have all of your trial rights. You still have all of the discovery that Mr. Gurewitz.
So let's go back to what we think the legislature intended by the words that they placed in this statute. You think their intent was to recognize that someone might have a preliminary examination, I guess, based at the discretion or grace of a judge, but that they might not? Is that what you think they intended when they made reference to the examining magistrate here?
Your Honor, I think what they recognized is that these hearings were happening, but that they were happening and whether there is a right to them going on are two very different things, and that's what this court expressed in Duncan.
So they were sort of agnostic. They're happening, but we don't really care if they happen or don't happen?
Your Honor, here, I'm sorry.
No, I'm trying to understand what they have to have done this for some reason, included this examining magistrate language, and if you don't think it's because they contemplated a preliminary exam occurring in these cases, I'm just trying to understand why you think they went to the trouble of putting the phrase in there. Is it, and it sounds like you think they're agnostic. They're saying these things are happening, and so if they happen for whatever reason they're happening, they're not because of us or anything we want to happen or don't, or, you know, we don't care if they happen or don't happen, but if they're gonna happen, it's gonna be in front of a different judge. That's how you interpret that phrase.
I don't know if I put it quite like that, Your Honor, but I think the problem that we all inherently recognize and that we make note of in our brief is these are certainly not the most well-worded set of statutes that I think we've ever seen. I see Justice McCormick smiling. And so the problem is then we have to figure out legislative intent. And there is not a lot of history on what the legislative intent was behind these statutes. We know what was happening. But this isn't a situation where the legislature wrote an act for them to use legislating.
Let me, because I know I'm now way over time and we have lots more to go here, but let me just ask one last follow-up, which is, my understanding or my reading of your position is you think the legislature was agnostic on whether people had exams or didn't have exams. They recognized that it happened, but they didn't really care one way or the other. But let's just assume that's your position. What standard is there for a judge to determine whether to grant an exam or not in that conception of this statute? When would a judge know when to offer one and when not to, or is it just you're just left to the personal idiosyncrasies of the individual judge?
Your Honor, I agree that was, I don't have an answer for that. And the problem is there is no historical suggestion of what kind of decisions were made when they were made. Like I said, the problem with all of this is even Duncan recognized that there were instances where these exams were happening, whether or not they were supposed to be happening or not. And even...
What about does that historical practice does that inform our interpretation of the statute, that the legislature was so dialed into this, acknowledging that these things were happening, that they put a disqualification provision in place? In other words, if they wanted to exclude preliminary examinations, if they said, oh my, this is terrible, we don't want this to happen, they easily could have said that you don't get an exam here, right? Not the flip side of what you're looking for, that you do get one. They could have said you don't get one, right?
Your Honor, they certainly could have.
So they knew these were happening routinely, and they wanted you to have a different judge if you were going to get one. That's all we know from the language.
That they didn't want the one-person grand juror having anything to do with it, Your Honor.
So if you got one for any reason, it has to be in front of a different judge.
I'm sorry, Your Honor,
I'm just restating your
If you
position.
get lucky enough to get one, just make sure it's somewhere else.
Yeah, you have to have it in front of a different judge. Okay, thank you, counsel.
Thank you, Your Honors.
Try to be succinct. I think there are several salient points that arise from Mr. Kessel's arguments. One that is clear is that the statute provides for an alternative means of investigation. We are not looking to obtain something to which the statute does not say that we're entitled. The statute provides for preliminary examination by the phrase that has been referred to. And particularly, would note that the language of the 1947 amendment disqualifying the inquiring judge, the inquisitor, from conducting the exam, says specifically that the judge is disqualified from acting as the examining magistrate. The phrase was included specifically to ensure that the judge would not act as the magistrate at a preliminary examination. It couldn't be clearer. And that's what the 1947 State Bar Committee report indicates. The supplemental response brief, I think it was the response brief from the people, also agrees that, in fact, there is a right to a preliminary examination, but characterizes it as a, quote, unquote, a possibility. But in their brief, as Mr. Kessel was unable to do here, there's no explanation for what the criteria is in the statute for applying that. It would seem that if the legislature intended to only make it a possibility, there would have been some guidance provided to when that would apply. It's not there. It's not there. At bottom, where we get to is that the statute, as enacted in 1917, included the specific requirement that the matter shall proceed as in like manner as upon formal complaint then. The legislature has acted to amend the statute in 1921 to grant authority to the judge to make a report to a public employer without changing this language that we're dealing with today. There has been never any attempt to change even a letter or a comma of the phrase requiring a preliminary examination to the present time. And for all those reasons, I'd ask this court to rule consistently with the arguments we've made and to reverse the decision of the circuit court denying our motion requesting a preliminary examination. Thank you.
Thank you, counsel. The case will be submitted.